No. Hey, Mr. Stengel, you're up.
Thank you, Your Honor. Your Honors, good morning. Dan Stengel from Associates and Bruce L. Shiner in Fort Myers, here on behalf of Kenneth Irvin Jr., the plaintiff and appellant. May it please the court. Your Honors, we're here on a very simple matter deciding whether the non-binding arbitration process that is established in statute, carried out by rule of the Supreme Court, and subject to a referral to non-binding arbitration under the conditions and referrals and reservations of the trial judge. Whether after that arbitration hearing ends and the judge provides the parties with the arbitration award and neither party requests a trial de novo, then that final arbitration award, the arbitration award becomes final and fixed and enforceable. That is how the process is supposed to work. That is not at all how the process worked here. In this case,
you would concede that in an arbitration, let's just maybe start at basics. Not all of the issues, some subset of the issues required to resolve a case could be referred to arbitration as opposed to all issues.
Absolutely, Your Honor. And in this case, costs, the referral order said that the arbitrator should determine costs and that attorney fees are generally left to the trial court following the arbitration.
But didn't the arbitrator reserve not just on collateral sources, but also on other tortfeasors?
No, he didn't reserve on that. He said there was no argument about it.
He said, but he said, I'm not resolving that. And he said, if there, you don't infer from what was said by the arbitrator that he was reserving in the event that there are other tortfeasors?
No, Your Honor, I don't believe he's allowed to do that because then there is never any finality. Now, here you are allowed, if the arbitrator has missed something or has done something other than the referral, that happened here, and the defendant, who's the appellee here, contested that he said he was not dealing with costs, even though the referral said costs. On the day of the last day, the 20 days where it was you ask for a trial or the arbitration award becomes final, fixed, and enforceable. On that day, they said to the judge, we'd like the arbitrator to consider costs because we can't evaluate what our exposure is unless those costs are done. That was on the last day, and that would have been effective for a referral back to the arbitrator saying the arbitrator's work was not done. And that is allowable. The courts have said that. If the arbitrator doesn't do his work, then before the expiration of the drop dead, I need to ask for trial on the 20th day, they did that. And then they withdrew it. And that would have been effective to send it back, but they didn't. They withdrew their motion. And then they filed the same thing that the prevailing party, which was Mr. Irvin, the appellant herein, they filed the same proposed final order as the appellant did, which is for the full vote of $11,649,770. And they expressly put that in their proposed final order. And that stayed on the calendar for some weeks. And then some 2.5 months after the arbitration award, they amended their proposed final judgment, asking for the settlements, one of which took place before the arbitration and one of which took place a month and a half roughly after the arbitration and was finalized then. The negotiations for that settlement were well known to the defendant from the moment that it was on the record.
Something also seemed to be at least known to the arbitrator too, while reading, there may be other tortfeasors. At this stage, there was no argument as to the fault of others who might be culpable. Thus, while not addressing this opinion and award, while not addressing this opinion and award is not meant to be dispositive of issues and evidence outside the record.
It can't be, Your Honor. It can't be outside of the record. This, the judge sent it to non-binding arbitration. And that statement does not comport with the arbitrator saying, I'm not done, or the court should have reserved this. These are not automatic deductions and these set-offs, and that is precisely.
The arbitrator independently talked about set-offs.
Yes, sir, he did. But
Yeah.
that's
because the arbitrator did not conflate set-offs and other tortfeasors.
no, sir, he did not. No, sir, he did not. He said there are other tortfeasors. That should have served as a signal to the defense that they needed to raise those. They had not been raised or proved up. And to this day, Your Honor, they have not been proved up. And the critical point here is, that settlements are in tort actions are not automatically set off, because non-economic damages, pain and suffering, those are not. The Derivative Liability Act under the Dram Shop law here, that doesn't apply. And those are not subject to set off. The law is highly clear on that point from this court and from every other DCA, that pain and suffering is not a set off. They were set off here. These settlements.
And they were set off after the arbitration, non-binding arbitration award was submitted, and after the period for objecting to it or requesting trial de novo had expired, correct?
Yes, Your Honor, by 2.5 months.
So at that point, I mean, had this arisen during that time, as you point out, perhaps it could have gone back and you could have litigated that in the arbitration.
Yes,
What
sir.
parts of set off should come up. But I don't see how under the statute anything can happen other than, either it goes back for reconsideration, or you have a trial de novo, or there's a judgment with execution on the request of the parties. I don't know where the set-offs can come in under that statute.
Well, under the statute, for example, I believe it was the Diaz case versus Andy. They sent it back for a determination of costs and a determination to apply the set-offs. There are cases where it is clearly the parties do not dispute that the settlements were for economic damages.
Right.
That never happened here.
Right. So
No,
all I'm doing is reading the text of the statute. Textualism is a big thing nowadays,
Yes, sir. Yes, sir. The statutes for set-off require these issues to be raised at trial. As an alternative to trial, they had to have been raised at some point. They could have been raised when the judge made the referral saying either reserve set-offs. They knew about the LJ set-off. The defense did for months. It took place in 2017.
But the point being is it didn't come up until after you had after your right to request a trial de novo had expired.
Yes, sir. But the arbitration award, Your Honor, became fixed. They waived a number.
Well, those two things happened at the same time, did they not? I mean, you had the right to request a trial de novo during the period of time, and if no one requests it, it becomes fixed, and you get a judgment for which execution issues. That's how the statute works.
Yes, sir.
So if there's going to be any litigation, any contest over set-offs, it should rightfully come up before or during the arbitration or be reserved as a result of the arbitration. And that didn't happen here.
None of that happened here, Your Honor. The plaintiff was on absolutely no notice that this would be brought up, and in fact is still under that misapprehension as it was applied by the trial judge in this case. The trial judge made a simple mathematical deduction. She never examined the settlements. There was no opportunity for her to examine the settlements. She simply took these settlements and after the fact,
took them off the arbitration
took them
award.
off the arbitration award. Yes,
Right.
Your Honor, that's precisely what happened. And that's not lawful. If you can, what other among the 15 or 16 affirmative defenses that they alleged a year before the arbitration should have put us on notice, and that not only that could ripen without being proven up? These settlements were never, they don't follow the set-off statute. If you can ask for a non-binding arbitration without reserving set-offs to the judge or asking that set-offs be deferred and referred to the arbitrator, if you don't do that and you don't raise it at the arbitration, you waive it. You waive it just like you waive any other affirmative defense by not having timely raised it. They had many opportunities to do so before the arbitration, at the arbitration, or after the arbitration, had they not raised it before the arbitration became the substitute for the judgment, and that the trial court had no discretion except to enter such orders and judgments as may be required to carry out the terms of the decision. Now, what
Diaz, is that a distinction that I mean, in Diaz, we sent it back.
Yes.
They said the appellate court sent it back to send it back to the arbitrator. Why wouldn't that be the solution here? Are you saying it's because it was in Diaz, it was raised prior to?
In Diaz, it was raised. And
thus would have, that sending it back would have been not outside the terms of the non-binding arbitration statute.
That is correct.
Here it was not raised, and there's no provision in the non-binding arbitration statute that would allow it to be raised in order to modify the judgment called for by the arbitration award.
Not after the fact, Your Honor, not some 2.5 months after the arbitration award became fixed and final. This is a great process because it is non-binding. You either accept the award or appeal a portion of the award or none of the award.
But
or
your side, you lost the opportunity to reject the award because this was not raised until after the period for seeking a trial de novo had expired, correct?
That is correct, Your Honor. We were not on notice. It was, the evaluation was according to the law, the Supreme Court rule, and the arbitration.
So at that point, not even if you had said, you know, legally they're entitled to some setup, but we disagree with how much of these settlements should be settled, you had no opportunity to do that.
Had absolutely no opportunity. These were not proven up. It was never, a trial judge never looked at them as they would have for set off after a trial and determined what those settlements were for.
Set off after a trial, but before entry of a net judgment.
That's correct. Had the judgment been entered for the month and a half or the many weeks that the defense had proposed for entry of the 11,649,000 and some for this critically injured, catastrophic accident. And then after the fact, 2.5 months later, they said, oh, the settlement before that took place before arbitration, we want that deducted. And
so if the trial court had entered judgment in accordance with the arbitration award and then performed the analysis and then done the set off, it would be okay?
If it had been reserved and properly preserved.
Right,
because
it would be
Well, we're
reserved
talking,
in
I'm
the-
not
it would
talking
be
about that.
reserved
anymore.
in
I'm talking about the
judgment,
fact that under, is it Felgenhauer or whatever case, it is proper for the court, there is a case and if it's Felgenhauer,
yeah,
I think,
we know it.
that says it's actually not an affirmative defense. It, requires, it is a process by which the trial court sets off the judgment after the judgment. But you're saying that here the problem why that doesn't apply is because the trial court set it off prior to entering judgment in accordance with the arbitration award?
No, Your Honor, not at all. That was a jury trial case. That jury trial case has no.
I'm just asking what you're saying about the chronology.
Oh, well, what I'm in that case, for example, it was undisputed what those settlements were for. They were for economic damages, so they were subject to the set off.
Well, I'm just trying to isolate arguments. So let's say that there was no issue about establishing what the settlements were for.
We're looking at procedurally, at what point do the set-offs get applied?
And also what point
Verdict,
are they
judgment, set-off,
adjudicated?
Verdict, set-off, judgment, that sort,
Yes. As Judge Northcutt, I believe, and I don't want to speak for him, but I understood him to be saying that you have to raise this before the arbitration award becomes final. If you allow it to become final by not asking for a trial de novo, you lose whatever you have not previously raised. To have the trial judge either allow it.
But if this were this alternative dispute resolution.
Yes, sir.
Just to play devil's advocate here. So, and it's a substitute for a trial.
Yes, sir.
And okay. And yes, and even acknowledging that, there are things that an arbitrator does other than resolve factual disputes, but here, there was a reservation by the arbitrator, we'll accept that for the sake of my discussion I'm having with you now.
Okay.
And there's just in Felgenhauer, there was a jury trial. And then at some point subsequent to the judgment, the trial court, pursuant to 68.041 and 46015, set off the settlements. Presumably, and in there, it's clear that there was no factual, as the settlements were not adduced as facts because you weren't supposed to show that to the jury. So at some point after all is said and done, the trial court had the authority to set off the settlements. So here, if arbitration is the alternative dispute resolution substitute for the trial, why was it not under Felgenhauer within the court's authority to perform the set off, something that happens after the dispute resolution? Here, arbitration; there, the trial.
well, I would suggest though that Felgenhauer says after the verdict.
After the verdict, there was
The
no
judge
verdict.
then enters a net judgment after applying the set-offs, correct? Isn't that generally how it works? It's been a long time since I did it.
No, yes, sir. That's precisely it.
So here you have a statute that says you raise this stuff, you request a trial de novo or whatever, but at the end of that period, the judge enters a judgment to enforce the arbitration award, and execution will issue on it. Doesn't say anything about then after that judgment is entered, you can then get set-offs. In the Felgenhauer situation, you got verdict, set-offs applied, judgment entered on the verdict with the set-offs applied. That's not what happened here.
Correct. And the arbitrator in this case is no substitute for the jury. He is
and correct me if I'm wrong. If I understood, the arbitrator didn't reserve any issues, correct? The arbitrator just noted that there are other tortfeasors, potential tortfeasors, and I think maybe one way to, and you correct me if I'm wrong, and Ms. Valdez certainly will if she thinks so, is what the arbitrator is saying is this isn't going to be, binding as to your disputes with any of the other tortfeasors. This is just between these parties, correct?
That is right.
But it wasn't a reservation to determine what the obligations of those other tortfeasors would be.
That's correct, Your Honor. There was no mention of it. Had been no mention of it since a year before the arbitration began in an affirmative defense, and was not raised again by
Mr. Stingo,
until 2.5 months after the
after the,
arbitration award became final. And Your Honor, I don't know. I apologize. I don't know whether I reserved any time
I was
for.
about to bring that, that's why I was about to bring that up. You did not, I meant to ask you at the 5-minute mark, we're beyond that, but I'll still say give you 3 minutes for rebuttal because we.
That's what I was
use up your
about
time.
to ask for.
Okay.
Are we up to that point, Your Honor?
Yes, we are.
Thank you, sir.
All right. Thank you, Mr. Stingo. Okay, Ms. Valdez.
Hi, good morning, Your Honors. May it please the court, Alexandra Valdez on behalf of the appellee, Mr. Saladay. If I could address a really important point up front factually that I don't think was addressed in Mr. Singel's argument, and that is this settlement that is at issue that was set off, this settlement was not entered until a month and a half after the time to request a trial de novo had expired. So this settlement didn't exist at the time that the parties could have contemplated set off, could have requested.
I thought there was one that was prior and one that came after.
That's correct, Your Honor, and that's another important point that I would like to know. Mr. Singel is not appealing the set off of the prior judgment. Mr. Singel has only asked this court to reverse and remand on the set off that took place after the time to appeal, or rather to request a trial de novo had expired. He has not raised any issue in his brief. In fact, the conclusion to his initial brief expressly requests only that the settlement asked to Moose Lodge be reversed and remanded. He has not requested.
Let me ask you a question, Ms. Valdez. Are we supposed to just ignore the terms of the 44.103(5) when it says you request a trial de novo, and if none is requested, the court just carries out the terms of the arbitrator's decision and a judgment is entered for which execution can issue?
No, Your Honor. However, if you.
So how do we bend that statute to accommodate this situation?
I think that there's an important distinction that needs to be made here. What the arbitrator determined, the issue that was before the arbitrator, and he clearly states it at record page 108, and if the court will bear with me, I'd like to read it. The issue is damages, as there is no dispute as to liability, causation, permanency, and plaintiff's entitlement to substantial damages. The arbitrator has been asked to issue an award determining and itemizing the extent of plaintiff's damages. That was the only issue that was before the arbitrator, the plaintiff's damages. To state that Mr. Saladay, who had no objection to the determination of damages as made by the arbitrator, should have requested a trial de novo within that period because of this issue of the set-off is a waste of judicial resources and the party's time. We had no objection to the calculation.
I'm not looking at policy here. You're making a policy argument. I'm looking at what the terms of the statute are that everybody's telling me the text of the statute controls our decision making.
I understand, Your Honor.
That is the word in the land. And I'm looking at the statute and I don't see how you get set-offs after the period for requesting trial de novo has expired.
And I think Judge Atkinson, noted that and hit the nail on the head. You know, the issue before the arbitrator can be limited and was limited in this circumstance. The issue before the arbitrator was whether, the determination of damages, and that's what the arbitrator passed upon. That's what the award provides for. And the arbitrator clearly set out in his award that there were other issues that were not being addressed or contemplated at that moment. One of those points, for example, is a footnote that the arbitrator placed in the award, which notes that collateral set-offs are to be taken by the trial court. And this implies that this was to be done after entry of the arbitration award.
Well, I'm looking at the award.
Correct.
Was the negligence, he did it like a jury verdict. Was there negligence on the part of Saladay, legal cause of loss of damage to Kenneth Irvin? Yes. Was there negligence on the part of Kenneth Irvin, which is a legal cause of his injuries? No. what is the total amount of damages, et cetera, as a result of the accident? He puts the figures down. I don't see how you get anywhere beyond other than a judgment for Mr. Irvin in that amount.
Well, and I
Unless you're
think,
going to go and say, okay, there are other considerations, but we need to have a trial de novo, because otherwise the statute says he gets an executable judgment.
well, Your Honor, I think the Felgenhauser, I apologize, decision from this court is instructive here. That decision indicates the issue of set-off is for the trial court to determine after a verdict and after a trial. There is nothing to be presented.
After a verdict, it doesn't say after the judgment is entered. So it seems, so the question that I'm asking is why, how can we possibly interpret this arbitration statute as permitting you to come back after the time for the expiration of the trial de novo, when you're supposed to get a judgment in the amount of the award, and say, no, we want a judgment in some other amount?
Your Honor, I think part of the issue also, and that I take issue with in Mr. Stengel's presentation, is there was never any dispute, and I don't believe that there can be a dispute, that Mr. Saladay was entitled to this set-off. These settlements were...
Possibly some set-off. It depends on what the elements of those settlements were.
Well, but Your Honor, and the trial court expressly asked this of counsel at the hearing on multiple occasions. Give me a legal basis why, and this is on pages 15 through 17 of the supplemental record, give me a legal basis why they would not be entitled to this set-off, and counsel could not provide one at the time. And the reason is
Except the statute says maybe you should have brought it up during the time for trial de novo.
well, but again, Your Honor, and that takes us back to the timeline. This settlement didn't exist, and so how could we have raised it? Mr. Stengel has not taken an issue. I apologize, Mr. Irving has not taken an issue with the settlement that was taken that did exist at that time, the set-off for that settlement. So you're asking us to raise an issue during a time period in which that issue did not exist. There was no settlement for us to raise and request as a set-off. So
Is there any law that prohibits you from seeking a set-off after the entry of a final judgment?
there is not that I am aware of, Your
And
Honor.
all you would have to do is carry your burden of persuasion that says how the set-off numbers were itemized. Is that correct?
That's correct, Your Honor.
So when the trial judge asked counsel, let me say Mr. Stingel's position about any legal position, whose burden of persuasion should that have been? His or yours? To show there's any lawful reason why you get to deduct it now. If the statute says the judgment has to be entered within 20 days.
I believe at that point in the hearing, we had established our legal basis for the set-off under 46015 and 768041. And so I believe at that point it was.
There's a difference between a legal set-off and the procedural time when it is invoked. If, as Judge Northcutt says, the statute and the rule says the window opens and then it slams shut on your finger 20 days later, if you haven't got it done, you're liable to lose your fingers. You are a little bit late to the dance, aren't you? Particularly when in the 8th of August or sometime in August, you asked the trial court to enter the judgment in the original full amount. Is that right?
That's correct, Your Honor.
We
However,
are way late.
However, at that point, again, this settlement didn't exist. And so it seems.
Going back, oh, I'm sorry to interrupt you. Go ahead, counsel.
I'm sorry. I want to emphasize, I understand the intent behind the statute, but if this didn't exist at the time, how could we possibly request it?
That's why you could request it after the entry of the final judgment, correct?
Well, Your Honor, according to Mr. Single's position, we couldn't do it then either because the time has expired. I mean, I believe that's.
I'm
been
not
established.
sure that's his position.
My question is, under the statute, under the arbitration statute, how in the world could you? Because under the arbitration statute, if that were strictly applied under its text, he's got an executable judgment in the amount of the arbitration award.
Your Honor, I mean, I think the difficulty.
Maybe you could try to, I don't know, maybe the law would allow you to like pay what you think you owe after a possible set off and then demand a satisfaction and you could then litigate it. I don't know, but I'm just looking at the arbitration statute and what it says by its terms.
Your Honor, and I understand that, I think the issue that I'm having with that is if we were to apply the arbitration statute in that way, it essentially avoids the intent of the set-off statutes. The set-off statutes are intended to prevent a party from double recovering. And that's exactly what would happen here. And I find that particularly troublesome.
Allegedly, Mr. Stingle says not necessarily. Because he hasn't had, you have not litigated what were the elements of those settlements and whether they would be properly set off against, his recovery under the arbitration agreement or the
Your Honor,
decision.
but we attempted to litigate that and we raised the issue, and Mr. Stingle had, or trial counsel at the time for the plaintiff had the opportunity to dispute that, and they chose not to do that. And instead they rested on the argument of the timing. And I think that is troublesome given that the negotiations with this particular third-party tortfeasor had been going on since prior to the arbitration. And for some unknown reason, the settlement was not actually entered into until a month and a half after the arbitration award became final.
So let me ask you this.
I apologize.
Don't, because I'm interrupting you. You're not interrupting me. Your client adduced evidence of the settlement agreements, correct?
Correct, Your Honor.
And the trial court determined that set-off was warranted, correct?
Correct, Your Honor.
So would you say you met your burden?
I believe that we did.
So then you believe you did. And then there's another question that I think got elided by some other discussion. If this were a jury trial, regardless of whether this was a jury trial or a non-binding arbitration under the statute and rule, is it possible for a litigant to achieve a set-off against a judgment after the judgment has been entered?
I believe so, Your Honor. I believe that the issue, I traditionally, and in my experience, for example, the issues of collateral set-off and things of that nature are addressed before a final judgment is entered. I mean, parties generally try to have that accomplished before a final judgment.
So why is this any different?
I don't believe that there's any distinction here, Your Honor.
Understanding, as Judge Northcutt has said, the statute seems pretty clear that the trial court is, I think if the fourth ECA said it was mandamusable, it was a non-discretionary, duty to enter judgment in accordance with the arbitration award. Well, why would this be any different? And
I understand that, and I think that the issue to me really is that, I'm sorry, I just kind of lost my train of thought there. I'm sorry, what your question was?
well, from my questioning, I'm getting your answers. Your answers. One, you believe that, leaving aside the chronological difficulties, you made a showing, you adduced evidence of the settlements. The trial court made a ruling that the settlement agreements, that set-off was warranted. And then the next problem we have is chronology. And the chronology is that it happened, as opposed to Fahrenhauser, before judgment. Here it was after a judgment, by operation of law, since that your client didn't file a request for trial de novo. And then you were going to tell me why it's any different than it would be, say, if we weren't operating under the non-binding arbitration statute. In other words, if there had just been a jury award and a verdict and then a final judgment entered, what would be your recourse if there was a subsequent settlement or one you didn't know about, that you came aware of, that you wanted to have set off against the already entered judgment?
And I think that perhaps in that instance, it would fall under newly discovered evidence, and we may be able to come under 1.540 and request some type of relief from the judgment that has been entered in that circumstance.
So if that's the case, and that we get to that only because we're assuming that the non-binding, that what is entered as an operation of law pursuant to the statute and rule under the non-binding arbitration regime is a complete judgment not just a judgment with regard to certain aspects of the case and not others. And that's your alternative argument, correct? Which is that there were issues reserved, expressly reserved, and they didn't include really liability because it was understood, it was practically stipulated, and as well as the fact that there could be set-offs, and the fact that there could be other tortfeasors, which arguments have been made that was not actually a reservation, but there is that language in there. So what would you say to that?
That's correct, Your Honor. I would agree with that. And I understand again, the idea behind the non-binding arbitration statute and this idea that, final judgment results if you don't request that. But I think ultimately, we come to the same place had we requested a trial de novo and gone through arguably an entirely new trial. We would be at the same place. We would have properly requested the set-off when we needed to. Had by operation of law, the non-binding statute resulted in a final judgment when that time expired, this would equate to a situation like that, a request to set this off after the fact, which I think could be permissible as an argument of newly discovered evidence, because again, this settlement did not take place until after that time period had expired.
But you didn't file a 1.5 for a motion.
But you knew of the existence of other potential tortfeasors, correct?
That's correct, Your Honor, but we don't have any control over the timing of the settlement. And just as
Of course, but there's a big red flag that the arbitrator has waived in this award, and it could be that the plaintiff could have said, "Look, if I had known that you were going to set off all of this, I would have requested a trial de novo." And then he would have been directly under the set-off statute, which contemplates this happening between the verdict and the judgment. But what happens is the plaintiff's opportunity to do that has expired.
Your Honor,
right? And at least on the basis of how the wording of the statute is by that time, the judge should have entered a judgment that was executable.
the issue with that, Your Honor, I think that, in terms of analyzing as the plaintiff whether or not to request a trial de novo, the plaintiff had all the information available to them to make that determination. They were
Except they didn't know that the judge was just going to take the amounts of the settlements and just deduct them wholesale from the amount of the award. That part was unknown.
But Your Honor, they were aware that we were seeking set off. We had raised it as an affirmative defense, and whether there was a dispute as to the amount or the plaintiff wished to dispute the amount, they still knew that there was the potential for the set off. They still knew that legally speaking, these settlements could be set off. I mean, I don't think that there's a dispute.
So how do we fit that? How do we fit all of what you've just said into this statute, which doesn't seem to account for it at all? For that matter, under the set off statute, because it's like between the verdict and the judgment. That's what was Felgenhauer was about, between the verdict and the judgment, not after the judgment.
I mean, again, Your Honor, I think that if anybody could have foreseen this issue arising, it was the plaintiff. They were engaged in these settlement negotiations at the time. If they needed to request a trial de novo because they were concerned that these settlements would be set off in any form, they should have done so. We had no reason to request a trial de novo. We would have incurred additional fees had we requested a trial de novo if we didn't prevail on a better outcome in a trial. Why would we do that as a defendant when we've admitted liability and have no issue with the calculation of damages?
And Ms. Valdez, those are maybe great policy arguments. All I'm doing is reading the statute that the legislature enacted.
Given the questions about my co-panelists and myself, I'm wondering whether you ought to, or I would like to know what you have to say about the concept that a non-binding arbitration can can be confined to, we've already established, everyone established that you could have non-binding arbitration of less than the whole of the matters to be adjudicated in a lawsuit, right?
Correct.
Then is that what happened here? And if that's what happened here, could there be a judgment as to let's say it was the opposite, as to liability and not damages, and there's a judgment. The statute says the arbitrator's judgment, the arbitrator's award of, well, it's more of a legal determination of liability, is sacrosanct, and then the trial court has further work to do. What further work does the trial court have to do after entering judgment pursuant to the arbitration award? And is there any support for that work left to do, including a set off for subsequent settlement agreements?
I think, Your Honor, that, you know, there is no clear law on this issue. There is no clear case law on this issue. But I think that even considering the intent of the non-binding arbitration, it is recognized that there is still some work to do. What is that work that remains to do? The entry of a final judgment. And I think that when you take that into consideration with decisions such as Sully and Hauser, which indicate that when a court is entering final judgment, it is to consider and adjudicate these set-off issues, I don't see why it could not be done here in the manner that it was done.
And as Mr. Stengel did in his briefs, he's going to say, you know, it's an improper analog to a jury determination. But it sounds like what you're saying. I mean, there's a finder of fact. Sometimes it's a jury, sometimes it's a arbitrator or arbitration panel. And between the time that, in other words, you're equating what is described in the statute as an award that should become a judgment. You're saying the verdict becomes sacrosanct in the same way that the award, an award of everything will become sacrosanct. And between that time and the final judgment that's to be entered under the statute and rule, further work can be performed. Do you have cases in which that happened?
Your Honor, there is no case law that I was able to find that addressed this specific issue. Mr. Stengel did reference the Diaz case out of the 3rd DCA. However, in that circumstance, there was a different set-off issue involved. And I also believe that in that circumstance, you know, that was something that the arbitrator should have decided. And I think here part of the issue is, what was the arbitrator being asked to decide? As we noted, there can be a limitation on the issues the arbitrator determines. And I think here in his own award, the arbitrator clearly outlined that he was only determining the amount of damages. He left the issue of collateral source set off for the trial judge to determine. Had this been
he didn't just decide damages. He decided liability against your client too. I mean, you know, he decided issues of comparative negligence. He didn't decide issues of other parties' negligence.
There are no issues of comparative negligence here. We fully admitted liability. We fully admitted Mr. Irving's entitlement to damages. It was purely a determination of amount. There was no issue of comparative negligence, nor would there have been an issue of comparative negligence or apportionment of fault had this third party been involved, because this is a dram shop situation and the case law is clear that there is no issue of comparative fault in these situations.
Because it's a derivative, because of the derivative liability, is that what you're saying? So
that's correct, Your Honor. This is an issue of derivative liability, which means there is ample case law. It was cited to in our answer brief that indicates that there is no litigating of this issue at trial. There is no apportionment of fault. They could not have been named as a Fabry defendant since they weren't named as an actual defendant in the case. None of these issues would have been before the arbitrator at all because of the nature of the claim being made here. And so when it involves derivative liability, as it does in this case under 768-125, the case law in Florida is clear. The issue is one of set-off.
Set-off could have been before the arbitrator. I mean, it's not as though the arbitrator is a jury. arbitrator is the whole kit and caboodle. It's the finder of fact and the judge.
That's correct, Your Honor, but it wasn't clear that it was before the arbitrator. The arbitrator did not seem to interpret it as though it was before it or before him. And the trial court acknowledged that it wasn't clear at the subsequent hearing that the issue was before the arbitrator. So I think part of the difficulty is that was not clearly placed before the arbitrator. There are other cases in which the arbitrator is explicitly told you must decide X.
So what you're saying, you have an award from an arbitrator that said X defendant is liable 100%, and these are the damages, and there was no issue of neither comparative negligence or derivative negligence. And after a trial de novo has not been requested, those findings need to take the form of a final judgment. But before that final judgment is entered, derivative negligence issues in the form of set-off can be heard by the trial court because they were not a matter taken up by the arbitrator.
It's not so much an issue of derivative negligence, but the way the case law explains it is these settlements, what was paid by these parties because their liability is derivative, is essentially being considered a payment for the same damages that were awarded. And so again, the set-off statutes indicate, and the intent of the set-off statutes is to avoid a double recovery. The plaintiff was not entitled to recover the full amount of the arbitration award from our client and also recover for those same exact damages from these other third-party entities. It was, their liability was derivative, and so it was going to the same damages. And so the cases are clear that in that circumstance, that settlement with this derivatively liable third party becomes a set-off of the liability of the originally liable tortfeasor. And so that's what
we have helped you exceed your time.
I thank you, Your Honors, for your time and for your patience. Thank you.
Oh, you've done a good job under fire. So, all right, Mr. Stingle, you're up.
Thank you, Your Honors. I have a number of things to say. I hope I will be able to fit it into the 3 minutes. They didn't preserve their issues. That is fundamental to reading these statutes and to the process. Finality, it doesn't go on forever. You have to preserve your case.
But what was final?
What was
final, which is acknowledged by the arbitrator and seemingly acknowledged by the arbitrator and as perceived by the trial court, was something less than everybody's liability. It was just the immediate tortfeasor's liability.
That's correct. That's all he had in front of them.
Well, actually, didn't the arbitrator, Mr. Truitt, note in his award of damages, there's a footnote number 2 that alerts people that there may be a collateral damage set off on the past medical expenses, so that someone could have reserved that right under this non-binding arbitration, said, I want to litigate that issue. Do I understand how it works?
That is absolutely right. You can appeal part of the issue. They have to be preserved. They have
on page 114 of the record, question number 3, he identifies the amount of medical expenses, A, in the past, and there's a footnote 2, and it says, gross medical expenses are subject to reduction by the trial court for collateral sources, which would notify the parties, if I understand how this statute operates, that I would like to try that issue of collateral sources. And they were notified there, and they would have had arguably a 20-day period to do it.
Yes, sir.
How it works, I'm kind of somewhat new to this.
You're saying, Mr. Stringer, you're saying, in answer to Judge Castaneda's question, that they would have had to have requested a trial de novo on something that was not addressed, was explicitly not resolved by the arbitrator? Or is that footnote mean that they could, in the trial court, litigate set off for collateral sources?
Your Honor, let me answer your question quickly. This issue was never litigated. These settlements were never brought before the judge.
Right. So what I'm asking is conceptually, that footnote said, I'm not resolving this. That can be resolved after I'm done.
Right.
And are you saying that the the aggrieved party who wants those set-offs has to say within the 20 days, hey, I don't like this, I need to go back to the arbitrator? Or can the aggrieved party say, oh, well, I accept the arbitration award, that's fine. I didn't need trial de novo on anything in the arbitration award as it was resolved. But I want to now litigate in the circuit court set-offs.
They never preserved it for determination by the circuit court, and the circuit court didn't follow the law. And opposing counsel can say here that we were trying to hide the ball because and it's personal.
I don't think you answered my question.
I'm sorry, Your Honor.
I think
They
Judge
would not-
Atkinson is trying to figure out how
As it
procedurally
pertains
this would
to,
work.
Okay,
as it pertains to the set-offs that we all agree were specifically addressed in the footnote, would that, if the defendant had wanted to have those collateral sources set off, would that defendant have had to have, within the 20 days, requested a trial de novo or requested referral back to the arbitrator? Or could that defendant, having read that the footnote said that the arbitration award didn't adjudicate that, could the defendant then have it adjudicated by the circuit court after the 20 days?
I don't know the answer to that, Your Honor. I really don't. I don't know what the legal import of that is. All I know is that isn't what happened here. They
All we
knew-
know is no one but me mentioned it.
But if
And I'm not a
in
party to
fact,
anybody.
but if in fact we construe the language regarding other tortfeasors, and then there's a perfectly good alternative explanation as Judge Northcutt described for that language, as the similar reservation as the footnote, then it's an open question, isn't it? Whether that can be resolved, that must be resolved by a request for a trial de novo, or whether
or
it could be-
reserved or brought up at some point other than 2.5 months later. And they say, we couldn't have anticipated this settlement, but that isn't so. This is a dram shop law. The defendant testified that he had drunk all day long, as he did most Saturdays at Moose Lodge, and that he went and he did it every Saturday. Our complaint, would have alleged that they knew he was habitually addicted to alcohol. They served him until the point he was intoxicated. Settlement negotiations had gone on. Even the arbitration was delayed at the request of the parties, so the settlement with Moose Lodge could continue and be resolved before the arbitration. It wasn't. And instead, at a hearing, that for the trial judge to decide whether these should have been, whether set-off could still be allowed or it was waived, the trial judge and opposing counsel tried to turn it into an evidentiary hearing on the settlements. It wasn't about the settlements. If they had appropriately brought those before the judge, then the judge could have determined set-off, which the statutes and the common law make clear are not automatic. They are for the same damages.
But it sounds as though, and Judge Northcott's going to cut me off, it sounds as though they did. I don't understand, honestly, that it sounds as though they were brought before the court. The court made a determination. We have a problem with chronology, potentially, as everyone's been talking about. And then your client had the opportunity to say, oh, no, those shouldn't be set off in their entirety. Are you saying there was no opportunity to be heard? Or are you just saying that hearing took place at a time in which the Rubicon had been crossed?
That was what the hearing was about, was whether the Rubicon was crossed. And there are—
I see what you're saying.
Sir?
I see what you're saying. You're saying you feel like that
they didn't preserve
I'll
it.
go back and look at the transcript of the hearing again.
They didn't preserve it. And Your Honor, we were not on notice that we were to bring the settlements before the judge for a determination as to what amounts of those settlements were subject to set-offs and what weren't. What was for pain and suffering? $5 million of the
Okay.
arbitration award was for pain and suffering. And to this day, the trial judge has not looked at those settlements to determine whether they should be set off or not. And I
Okay, we
would
have
not
used
any
a lot
position
of time, and I didn't cut Judge Atkinson off, so I'm cutting you off, Mr. Stingle.
Thank your honors. I
Thank you both very much.
Thank you
Uh,
both.
just,
Appreciate
uh,
it. Thank you very much.
Click the leave buttons on your screen and off you go.
Hit the
thank you.
leave.